As I say, I'm Jill O'Dare. I specialise in all aspects of employment law with a particular emphasis on discrimination and human rights. I'll be opening up, and then our second speaker this afternoon will be my colleague Sinead King, an employment law barrister who works with a wide range of individuals, businesses and external HR companies. Her focus is providing legal advice and representation at all levels to companies and their employees in relation to all aspects of their business. And finally, you'll hear from Fergus McCombie, who specialises in employment law, commercial and business disputes, cyber data and technology. He recognises and represents claimants and responds at all levels in the whole range of tribunal work, including unfair dismissal, discrimination, equal pay, whistleblowing, TUPE, contractual issues, and holidays. Let's begin at the beginning with one of the most basic, but yet perhaps still unanswered questions in this area, which is to what extent does the law protect those who are gender fluid? This is really a question about the true extent of Section 7 of the Equality Act, which, as we all know, says this: a person has the protected characteristic of gender reassignment if the person is proposing to undergo, is undergoing, or has undergone a process or part of a process for the purpose of reassigning the person's sex by changing the physiological or other attributes of sex. Does this cover and protect people who have not journeyed from one sex to the other and perhaps have no intention of doing so? They regard themselves as gender fluid. That was the position of the claimant in a very well-known recent tribunal decision called Taylor and Jaguar Land Rover. The tribunal in that case held that a gender fluid person was protected. It held that the text of Section 7 was ambiguous, that justified visiting Hansard, where the tribunal held there was material sufficient to indicate that Parliament had intended in 2010 to protect those who were gender fluid. It came to that conclusion, perhaps surprisingly, even though the government itself at about the same time had concluded that the Gender Recognition Act needed to be amended to allow self-identification of gender. This issue was considered in passing by the EAT in Forstater, which is best known for other issues to which we'll come. And it seemed to conclude that the answer was no. Section 7 means what it appears to mean, that it can only apply to those who are on a journey. However, Mr. Justice Chowdhury, the President, held or stated fairly clearly that in his view, those who are gender fluid were protected by the decision of the ECJ in P&S and Cornwall as long ago as 1996. That case concerned a council employee who was dismissed because she was about to undergo surgery. But the ECJ held that she was protected by the Equal Treatment Directive, which protects which deals with not just discrimination on the grounds of gender, but discrimination on the grounds of sexual identity. There are a number of questions which arise from that decision. One is whether the sex discrimination provisions, in particular Section 11 of the Equality Act can be read so as to give effect to that decision. But they probably can, given the breadth of the interpretative obligation which existed until the Withdrawal Act, which of course leads us nicely to the question of what effect Brexit and the Withdrawal Act has on the Cornwall decision. In effect, it has been provided that only the Court of Appeal or the Supreme Court can choose to depart from retained EU law. So it seems to me that certainly at ET and EAT level, the President is right in thinking that the Cornwall decision does extend discrimination protection to those who are gender fluid, but not via Section 7. Another issue that arises here is whether it is unlawful to positively discriminate in favour of a trans employee, which might sound a bizarre suggestion, but it has crossed my desk in praxis. To give a simple example, what if a non-trans employee complains that his trans colleague is being given vast amounts of time off to promote transgender equality in the workplace, with the non-trans colleague picking up the work? Something fairly similar to that might be thought to have happened in Taylor and Jaguar Land Rover. Again, this depends very much on the PNS and Cornwall decision. If it's unlawful to discriminate on the grounds of gender identity, even post-Brexit, then it must be, as part of that, unlawful to discriminate against someone, to discriminate positively in favour of someone because of their trans status. And that brings me nicely to the Forstater decision. Many of you will know the factual background, but I'll set it out just in case you're not. Claim was a radical feminist who was concerned that the transgender movement, by allowing self-identification of gender, had undermined the safety of women, particularly, for example, in women's refuges and changing rooms. And she believed that gender was determined at birth and could not be changed. As a consequence, she said that while she would, as a matter of politeness, respect chosen pronouns, she was not obliged to do so, because any obligation to do so is an obligation to believe that which she did not believe to be true. She was particularly clear that she would speak up when the issues were in relation to women's spaces. Her contract was not renewed, and she brought a claim for discrimination on the grounds of her beliefs, contrary to Section 10 of the Equality Act and Sections 9 and 10, Section 10 of the 9 rather of the ECHR. This case is primarily about whether her beliefs attracted even minimal protection, or whether they were out with what has become known as the Granger 5 criterion, on the grounds that they were not worthy of respect in a democratic society. The respondent won with that argument in the Employment Tribunal, which said that harassment was baked into her beliefs because of her views on gender pronouns. The decision was set aside by the EAT. Those, and I suspect it's many listening, who have struggled vainly to climb the perversity barrier will find remarkable the ease with which the EAT managed to overcome what looks like a finding of fact. But that's perhaps another point. The EAT held that the ET had actually misunderstood what Miss Forstater believed, and that she was not saying that she would, as a matter of course, misgender anybody. It all depended upon the facts and circumstances. That being so, said the EAT, it could not be said that her views would inevitably lead to harassment of the transgender community. And my colleague Sinead King is going to deal in more detail with this case in a moment. As I draw to the end of my time, I want to just make a few comments on the decision in Forstater. It is an important affirmation of the limits of unprotected beliefs, and we should all be glad for that. But on the other hand, there is something that's very disappointing about the Forstater decision. In particular, everything we're told is dependent on facts and circumstances of particular cases, whether or not the critic of the transgender movement in all the circumstances is harassing a trans person. That, it seems to me, provides very little guidance for well-intentioned employers. The judge even seems to say that in some circumstances that it's not necessarily harassing to refuse to recognise a gender recognition certificate as an employee, a fellow employee. And finally, we're no nearer to the answer to some of the biggest conundrums of this very complicated world, which is this: does a trans person have the right to use facilities which are set aside for members of the opposite sex? And we simply don't know the answer to that question. So that's all I have to say. I'll happily answer any questions as time goes on. I'm now going to hand you over to my colleague, Sinead King.
Thank you, Richard. So if Richard has talked about the protected characteristics of sex and gender reassignment and the issue of identity, what I'm going to focus on in Forstater and Page and what they have to say about the Section 10 Equality Act protected characteristic of belief. The issue for employers in a nutshell is this. Under Section 13 of the Equality Act, you can't subject employees and applicants to less favourable treatment because of a protected characteristic. And where that protected characteristic is gender reassignment, sex, or a Section 10 belief, there is no belief defence if you do. Under a Section 26, you can't subject an employee to unwanted treatment which relates to a protected characteristic and which has the objective effect of violating an employee's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. And an employer may find themselves vicariously liable for the acts of their employees when they fail to take sufficient steps to ensure that such harassment doesn't happen. But what we see with the advent of cancel culture is the growing perception that beliefs which demonstrate a failure to accept a crucial aspect of identity are in and of themselves an expression of hostility, which poses a threat to the person whose identity is not being accepted. In many ways, cancel culture is an important social corrective for those who have found themselves too regularly on the wrong end of violence or discrimination, and his experiences teaches them that such expressions of identity-denying belief may represent the thin end of the wedge. And in turn, cancel culture involves those who feel threatened and their supporters preemptively applying pressure to remove a person from a social or professional circle, whether online or social media or in person, as a way of nipping concerns in the bud. But cancel culture also sets a collision course with the rights which derive from the protected characteristic of belief. And if an employer allows employees to harass employees for their beliefs or subjects an employee to detrimental treatment because of their belief, then they may find themselves caught in the crossfire. So what I'm going to discuss in the next few minutes is where we are, and then I'm going to hand over to Fergus, who can discuss where employers go from here. So under Section 10 of the Equality Act, there are 3 types of protected belief. Firstly, a religious belief, which means any religion, and the majority of cases tend to involve established religions. Secondly, a philosophical belief. And in Nicholson and Granger, the EAT set out 5 defining elements of a qualifying philosophic belief. Firstly, it must be genuinely held. Secondly, it must be a belief and not an opinion or viewpoint based on the present state of information available. Thirdly, it must be a belief as to a weighty and substantial aspect of human life and behaviour. Fourthly, it must attain a certain level of cogency, seriousness, cohesion, and importance. And Granger 5, it must be worthy of respect in a democratic society, not incompatible with human dignity, and not in conflict with the fundamental rights of others. Effectively, what Granger's endeavours to do is to set out a rough and ready formula which captures a belief which has a similar heft to a religious belief without actually being one. It's designed to create some pretty low hurdles intended to exclude the trivial, flippant, and wholly unintelligible, but pretty much allowing other beliefs through. Thirdly, and far less explored in the case law, is the lack of religious or philosophical belief, which is also protected under Section 10. In fact, before Forstater, the only domestic case which considered the issue in depth was Lee and Asher's Baking Company Limited. In that case, a Northern Irish family bakery refused to write a message in favour of gay marriage on a cake because of their Christian beliefs. And their customer duly brought a claim that this amounted to discrimination on the grounds of religious or political belief or sexual orientation. Lee tends to be known as the gay cake case, not entirely inaptly, because Mr. Lee ultimately lost his case in the Supreme Court on the basis that it was the characteristics of the cake that were the problem, rather than the protected characteristics of the customer. There, the Supreme Court held that there was a distinction between an objection to a customer because of their beliefs and objecting to writing a message with which you profoundly disagree. The Supreme Court there considered that freedom of thought, conscience, and religion were vital in a pluralistic democracy, not just for the religious, but also for atheists, agnostics, skeptics, and the unconcerned. It held that obliging someone to manifest a belief they did not hold was not compatible with their Article 9 Convention right to freedom of thought, conscience, and religion, nor with the Article 10 right to freedom of expression, which it found contains the freedom not only to hold an opinion, the freedom to hold an opinion, but also the freedom to not hold an opinion, and the freedom not to be coerced into speech. There's relatively little case law in terms of Section 10, but in Page and the NHS Trust, the Court of Appeal has held that the key distinction is between cases where the reason for treatment is the fact that a claimant holds or manifests a protected belief, and 2 cases where the reason is that the claimant has manifested a belief in some particular way to which objection could justifiably be taken. So on the objectionable side of the line, Miss Ladili refused to perform civil partnerships whilst being paid to work as a registrar with a public authority with the duty not to discriminate against gay people. In Page and Lord Chancellor, a magistrate refused to apply the law and approve an order for gay adoption because he didn't believe in same-sex families because of his religious views. On the manifestation side of the line, by contrast, Mr. Smith wrote on his Facebook page that gay marriage was going too far. The High Court found his employer was not entitled to accuse him, let alone find him guilty of misconduct, nor to demote him when his colleagues complained about his attitude. And on analogous lines, in Serco and Redfern, in the absence of a suitable philosophical belief, when Mr. Redfern's employer was pressured by his union into dismissing him for his decision to stand for the BNP, he sought to make a direct race discrimination claim. Richard has discussed the basis on which that claim was dismissed, but the Court of Appeal also expressed the view that had Redfern sufficient service to bring an unfair dismissal claim, he was likely to have succeeded because his employer failed to demonstrate why his views were inconsistent with his role. And when Mr. Redfern took his case to Europe, the ECHR agreed that UK law had failed to adequately protect his right to his political beliefs. Page itself represents a narrowing of the line between neat expression and inappropriate manifestation. Mr. Page, in addition to his role as a magistrate, was a trust board member with an NHS trust, and the trust provided mental health services to the local community, including gay people. Mr. Page's public behaviour included conducting multiple press interviews where he complained about being persecuted for his beliefs that same-sex parenting was not normal, including an interview on Good Morning Britain, following the Lord Chancellor's objection to his previous behaviour as a magistrate. Now, there the court accepted that Mr. Page's public statements were likely to undermine the trust's relationship with vulnerable gay service users, which was likely to interfere with their willingness and ability to access mental health services that they vitally needed. And consequently, the trust was entitled to remove Page from the board. In the immortal phrase that you've heard from Richard and will hear from me again, it's all of the facts and circumstances of the case. However, the broad point of the Court of Appeal is that there are circumstances in which it is right to expect those who work for an institution, especially if they hold a high-profile position, to accept some limitations on how they express in public their beliefs on matters of particular sensitivity. But whether such limitations are justified in a particular case can only be judged by a careful assessment of all the circumstances and has to strike a fair balance between the rights of the individual to hold and manifest their beliefs on the one hand and the legitimate institutions of the institution for which they work on the other. Which brings us to Forstater. Ms. Forstater relied on two types of belief. Firstly, she relied on her gender-critical beliefs as a positive philosophical belief. Secondly, she relied on the lack of a philosophical belief, namely, she didn't believe in gender identity. Now, because the issue of whether her belief was protected was dealt with as a preliminary issue, there was no discussion or consideration of what Maya Forstater had actually said or done relative to her beliefs. Rather, the question was limited to whether she was entitled to manifest her beliefs at all. The key to an understanding of Forstater are firstly the central importance the ECHR places on freedom of thought, conscience and expression as necessary to maintain a pluralistic democracy, and secondly the political context of Maya Forstater's tweets. The issue is that Ms. Forstater had expressed her beliefs over Twitter in the context of the government's public consultation on whether the law on gender recognition should be changed. The distinction she sought to make, based on sex assigned at birth, reflected the legal status quo under political discussion and was expressed in the context of one side of an extremely heated political debate about whether the law should be changed. Whilst she was a feminist, her views or her skepticism were also shared by people who weren't feminists or hadn't made up their mind. And on the face of it, her public expressions of either kind of belief represented her participation within a democratic process. However, the EAT found that both her positive and negative beliefs failed Granger 5. Whilst the judgment provided lengthy commentary of alternative ways Ms. Forstater could express concerns about the need for cis-only spaces without holding her beliefs, the actual conclusion it came to about why her beliefs didn't qualify for protection came down to two very short findings. Firstly, that her beliefs were absolutist in nature, and secondly, that failing to accept that a trans woman is a woman is hurtful to others and therefore necessarily involves a violation of the dignity of others and necessarily involves harm. As a result, the tribunal found that Ms. Forstater was not entitled to manifest either a belief or a lack of belief, and was required to refer to trans women as women, irrespective of her beliefs or the context of her communications. Now, these were some surprising conclusions. Firstly, under Granger 2, to qualify as a belief under Section 10, there needs to be something more than an opinion based on the present state of information, which suggests a certain tendency towards absolutism is built into a Section 10 belief. And as the EAT observed, prescribing absolutist beliefs would deprive most religious views of protection. Secondly, as the EAT found, a trans campaigner called Christina Harris had also given undisputed evidence in the case in relation to supporting gender critical views, as had several academics in much more nuanced form. So it wasn't clear how the tribunal could have concluded that violating dignity inevitably followed, regardless of context or content, whenever or however gender critical views were expressed. In relation to her failure to believe in gender identity, the Employment Tribunal found that the only lack of belief that qualified for protection was a lack of belief which also met the 5 Granger tests. And as Ms. Forstater's positive beliefs were unworthy of respect, it necessarily follows that she was not entitled to manifest disbelief either. If the finding on the absence of belief stood and was binding on other tribunals, it would have had a chilling effect on the public consultation about whether the law should be changed. Those who entertained doubts they didn't know how to articulate or hadn't given sufficient thought to, or failed to appropriately express the orthodox gender identity view could find themselves at risk of less favourable treatment by their employer or targeted by fellow employees until they did express the orthodox view, regardless of their genuine thoughts on the matter. This would obviously have a distorting effect on any consultation exercise and the information that appeared in front of the government when it concluded its consultation. Moreover, the consequences would have been wider than the issue of gender identity. On Forstater ET logic, expressions of belief which would be deeply hurtful or offensive to many could remove the protection of Article 10. And so that logic could apply to any controversial issue framed as involving the acceptance of a core aspect of identity, and therefore likely to generate deep hurt and offence, whether involving issues of gender critical views, gay rights in Christians, or land rights in Israel and Palestine. It suggested that an employer may be entitled or indeed required to make a knee-jerk response. So it's not surprising that Forstater gained a great deal of media attention. However, Forstater wasn't a binding judgment, nor did it reflect the jurisprudence. And so, in my view, the EAT decision represents the underlining of the appropriate boundaries around public debate, which reflected the orthodox jurisprudence. The key to the judgment are Articles 9, 10, and 17 of the European Convention on Human Rights. Articles 9 and 10 guarantee very wide rights to freedom of thought, conscious religion, and freedom of speech and expression. As Article 17 prevents any state, group, or person from engaging in any activity or performing any act aimed at the destruction or limitation of any of the rights and freedoms of the Convention. The EAT held that the rights under Article 9 and 10 included the right to hold and manifest beliefs which had the potential to disturb, shock, or offend others. They included absolutist beliefs, and they also included a lack of belief, whether it arises from indifference, indecision, or otherwise. Accordingly, it found that Ms. Forstater's lack of belief in gender identity was enough in itself to qualify for protection. Applying Article 17, the EAT held that the only beliefs which were not worthy of protection under Granger 5 were those which represented an affront to Convention principles in a manner akin to presumed totalitarianism, advocating Nazism, or espousing violence or hatred in its gravest form. As such, very few beliefs would fail the hurdle. In Ms. Forstater's case, the EAT found that her views didn't come close to a statement of belief that sought to destroy the rights of trans persons, and rather the appropriate focus needed to be on the behaviour giving rise to the claim of discrimination. If those are the parameters, then the EAT found that it was the job of the state in a democracy to stay neutral between competing beliefs and to refrain from expressing any judgment as to whether one particular belief is more acceptable than any other, whilst ensuring that groups opposed to each other tolerate each other. Accordingly, it was not the job of tribunal to evaluate a belief according to some objective standard, let alone substitute its preferred view. Nor was it open to the tribunal to make a blanket prohibition on any expression of belief. So where does that leave us? Well, putting Page and Forstater together, what employers must do is focus on the behaviour that an employee is manifesting and to think carefully about whether and why it crosses the line. Now, consistently with its role as neutral umpire in the democratic battle for values, the EAT and Court of Appeal in both of these cases have declined to give any further helpful guidance beyond advising that how these issues would play out depends on all the circumstances of the case. So the question that employment lawyers have to answer is, what does this mean going forward for employers facing claims from employees relying on their Section 10 rights, or indeed forced to mediate between employees with deeply held and opposing beliefs? And the answer, Fergus, I will leave to you to answer.
Thank you, Sinead. Just a reminder to all our attendees to ask any question you like. The question panel is open. Please ask any question, basic or complex, and we'll do our best to answer it. So I want to deal with some of the practical implications of the matters that Sinead and Richard have been discussing, and I want to zoom back out to discuss it on the level of clash of rights and clash of beliefs cases, not just the transgender issue. We need to consider as employment lawyers what this all means for the workplace and what it all means for litigation. Litigation, of course, being the fallback position that employers always have to have a mind on. So points of friction can come up as between employees. You might have one employee who's reacted in a problematic way to a belief held by the other. That could result in a grievance. It could result in a low-level management request to intervene. It could amount to bullying. There's a range of potential difficulties and outcomes there. Obviously, it could result in a harassment or a victimization claim, and even potentially a whistleblowing claim if some kind of belief or denial of belief can be translated into a legal obligation. You may also have employer against employee friction, most likely where an employee's actions are said to be in contradiction with values held by the employer or to bring the employer in some way into disrepute. Social media, of course, looms large in that kind of issue, which was the very issue in the very factual issue in Forstater. So these can all be described, I say, as clash of rights cases on one way or another. In respect of the employer, it's the employer's supposed right to employ whomever it wishes or to protect its business in the way that it sees fit. It may be that actually, rather than rights, which are hard-edged rights, few and far between in employment law, these are better described as clash of freedoms cases. What the employer usually wants to do is to take the heat out of these situations. How do you do that? Well, it's not enough just to have a policy or to receive training. There's a lot of trite commentary out there that just says these things help. Well, of course they do, but history and experience shows that they're not close to being enough in themselves to prevent problems, and they're not enough to establish the statutory defence against harassment, if that's where you get to. So when I speak about policy, I mean not just the written document, but also the way it's interpreted, the way it's implied, the way it's applied, the way it's enforced. The culture of the place has to back up the neutral arbitrage that the policy aims to arrive at and its good intentions. And I'll come back to that neutrality point. So that's culture as it's demonstrated through the actions, particularly of the employer. If you wanted to minimize the risk in equalities, in the equality sphere, you'd be extremely cautious around work social events, for example, especially where alcohol is consumed. Consider the Tokyo Olympics and the case of Laurel Hubbard, the transgender weightlifter. It's very easy to see how a joyful discussion about Olympics could degenerate into a slanging match over accusations of misgendering and denial of trans rights when you get to those sports where those issues are particularly prevalent. So if you listen to some people and even some legal commentators, you'd think that we'd entirely abandoned the Enlightenment values of freedom of expression and thought. But luckily, the law is offering us some protection from those extremes. There's already, if you look hard enough, some judicial commentary to the effect that it's important not to encourage a culture of hypersensitivity. And one legal foundation for that is Section 26(4)(c) of the Equality Act, whether it's reasonable for conduct to have a harassing effect. That's given equal weight to the perception of the claimant and the other circumstances of the case. So it's simply wrong as a matter of law, and the law should not encourage policies to adopt an approach that elevates the perception of a claimant over objective reasonableness. It's also worth remembering that the appeal tribunal in Forstater, as Richard has covered, said that, and I put this broadly, misgendering does not inevitably amount to harassment. It's a fact-sensitive exercise for the tribunal to undertake. And crucially, of course, the act of misgendering does not mean that the belief standing behind that is not protected as a matter of law. That's the crucial takeaway from Forstater. So the importance of policies and training and culture, of course, lies partly in the weight that can be put through the statutory defence under Section 109 of the 2000 Act, the statutory defence to harassment. The employer has taken all reasonable steps to prevent it. And so from that perspective, I suggest that good policy will acknowledge the right to hold any particular belief, but will make clear there's a line to be drawn in respect of the manifestation of belief. Beliefs which are unpalatable or offensive to some can be expressed in verbal or non-verbal ways, but just not in a manner that it objectively veers away from being moderate and respectful. And so seen in that way, the law's doing no more than asserting those traditional values of tolerance, politeness, and respect. I would also say that a good policy will make clear that not all beliefs are protected. So at one end of the scale, there's of course the Granger test 5 and the Article 17 point that Sinead has talked about, those beliefs which operate to the exclusion of others. But at the other end of the scale, you've got silly beliefs like the belief that the moon is made of cheese. Now that's a silly example, but a better one and a more realistic one is an employee's fervent belief that they should have been promoted. Now that may satisfy various aspects of the Granger test, but a right not to be unfairly dismissed won't help that individual very much if their unhappiness is manifested in conduct, which is problematic. And of course, it's not going to be a protected belief anyway. So my third point about a good policy and good culture is more difficult, and it relates to the point I made earlier about neutrality. Many employers find it useful to set out values, which is said to inform their dealings both internally and externally. Often those values include diversity and inclusion, nothing objectionable about that, but the difficulty comes when that inclusiveness doesn't extend to those holding particular views. I think this is a problem which is often seen, but rarely remarked upon and hasn't yet translated itself into litigation. Any written document of values and any enforcement or culture based on them probably now can't exclude protected beliefs which are perhaps unfashionable or represent a minority of opinion. Some industries can be particularly susceptible to this. I'm thinking of creative industries, perhaps, cultural institutions and universities. There may also be vulnerability in institutions with charitable or political functions or public bodies such as local authorities. I received the Legal 500 survey this year, which asked me not to use gendered language when commenting on the person I'd been asked to comment on. I have to say that the form didn't really make it clear what that meant, but if a response were to be sent that used pronouns he or she in relation to the person being refereed, and it was rejected on that basis, the subject would probably have a legitimate complaint. The point is that the organizational culture which seeks to exclude certain protected views through its values or its culture won't be neutral and will be vulnerable. That is something I think that employers do need to have a mind on. Those who don't have strong views, or even people who are agnostic and don't care, also need to be protected. Another example, people wishing to specify relevant pronouns in their email sign-off. It would be taking a risk for an employer to ban that practice, but it's also taking a risk for an employer to require it of every single employee. Obviously, there are some names which can traditionally be given to any gender. Hillary or Rowan are examples of that, but an employee may legitimately believe that there can be no confusion of sex or gender in the right usage of the names Bernard and Bernadette, for example. They may simply have no wish to imply that they're at all interested in the issues of gender identity at all. And those kinds of beliefs are going to be protected. To enforce a blanket approach to matters such as your presentation to the outside world is going to be problematic, I would suggest. So moving away from policy and culture to pick up one or two other practical workplace issues. This zooms firmly back into the transgender matters. And the first of those that I want to mention is toilet arrangements. ACAS guidelines seem to suggest that trans people can choose which toilets to use. In the Taylor and Land Rover case, which Richard has referred to, the claimant was asked to use disabled facilities, and the tribunal made a finding that that was insulting and discriminatory. But that ignored a much earlier 2003 case in the Court of Appeal called Croft against Royal Mail, which considered the issue in much more detail and concluded that it's not discriminatory to ask an employee to use a unisex disabled toilet on an interim basis. And that's got an old case now, 2003. As Richard said, Forstater doesn't really solve this issue. It's something they'll have to wait for a suitable case. But in the meantime, there is a British standard provision of one toilet for every 25 women, one for every 50 men. So an approach which simply redesignated provision to bring the level below that standard is also going to be problematic. So the second issue in the workplace is the provision of information about a person who's somewhere on the transitioning spectrum. One obvious step is consultation with the individual about who they consider needs to know. It's important to bear in mind that Section 22 of the Gender Recognition Act provides for a criminal offence where an employer discloses the gender history of a person who has a recognition certificate, or even information about an application for certificate, and it's a strict liability offence. So there's danger there. People have to be properly educated. But also, transgender status and the relevant medical history is going to be special category GDPR data. So any processing of that will need to be covered by an Article 9 GDPR exemption. Many employers are going to gather information at the recruitment and the induction stages. So it's there where consideration needs to be given to asking recruits to self-describe. And then that sort of information will have a very high degree of privacy and confidentiality. And the final thing for large employers is to consider an equality impact assessment. That can help with all sorts of things, with the burden of proof, which I'll come to in a minute, but also a legitimate basis for action as opposed to something more nefarious. So I come then to, in the last minute or so, to the sharp end, where you've got problems. Litigation is either in prospect or is actually in process, and you've got tricky decisions to make about what evidence to call and how to deal with it. So you'll no doubt all be aware of the case of FOB against Royal Mail Group in the Supreme Court, which re-establishes the legal position about the burden of proof and discrimination claims. So the EET have thrown that into doubt by saying there's no burden at all on a claimant because of the Section 136 reversal of the burden of proof. The Supreme Court said that's wrong. Burden remains on the employee to establish facts from which a finding of discrimination could be made. The point is that you can look at all the evidence, as has always been the case, in order to decide whether that's happened. So the other interesting feature of that case, and this comes up all the time, especially in historic discrimination cases or cases where witnesses have left an organisation, where the respondent in that case didn't call witnesses about the allegedly discriminatory recruitment exercises that had taken place. So they didn't call evidence about what had gone on in the minds of the alleged discriminators. Obviously, that's a very risky tactic if you've got witnesses who you just don't want to put on the stand, but it's not enough in itself for the drawing of an adverse inference against an employer, merely that the evidence hasn't been given. There needs to be consideration of why that's happened, how it's happened, whether any relevant evidence can be given by those witnesses, and the significance to the case as a whole. So, absent that evidence, a claimant will still need to prove those facts from which an inference of discrimination can be drawn before the burden of proof will reverse. I'm going to finish with a classic employment law non-exhaustive list of things which might help or hinder an employer in respect of the drawing of inferences. Hopefully some of these will trigger a bit of recall of what I've been talking about for the past few minutes. So my first one is a failure to deal with offensive expressions of belief as potential misconduct matters. The line is still there between manifestation and belief. And misgendering that's deliberate and offensive is still, of course, very likely to be found to be something which an employer should have dealt with. So there's that one. There's a failure on the part of an employer to deal with grievances or low-level complaints about transgender or belief matters. That's going to be problematic if it can be made relevant to your case in hand in terms of inferences to be drawn. A failure to act neutrally and demonstrate that neutrality as between differing protected beliefs, even those which are unfashionable or minority. Organizational pressure to affirm or contribute to a particular cause implying a belief. That is going to be, I suggest, problematic when assessing whether inferences should be drawn in favor of somebody who doesn't manifest that belief. Written policies which fail to engage with at least some of the nuances in general and flexible terms of matters of belief and transgender. And the last point, something that has been in the news a lot recently, training from highly controversial and one-sided sources. Stonewall has fallen foul of various reports, and I make no comment at all on the legitimacy or veracity of those reports, but you can see the problems that might result if you are perceived to have given weight to one type of belief over another. That's the sort of thing I suggest which would make a tribunal feel that actually it's the belief rather than the manifestation of your claimant which is being attacked here. So that is my lot on my particular segment of the talk. We do have a couple of questions. So I'm going to, obviously Richard or Sinead are going to jump into these as they want. So the first one is, does employee discrimination on protected gender status and characteristics extend to an employee when they are representing an employer on social media channels such as LinkedIn? Well, since I'm speaking, why don't I deal with that? That is going to be a classic kind of scenario where an employer says, well, you're representing our organization. And so there are difficult questions there that need to be grappled with in respect of the difficulties of bringing an organization into disrepute. When social media activity is in contravention of policy which says just don't do anything on social media, obviously that's a highly remote case. But anything which is likely to be seen as offensive or not put in a calm, considered, measured way is going to be susceptible to disciplinary action. So the answer is the protection does apply even to activity outside the workplace. Certainly in respect of activity purporting to represent an employer, and it's going to be protected. The belief itself, rather, is going to be protected. The manifestation of belief will not be protected as a matter of law. The manifestation will be up for grabs as a question of conduct, whether it fell over the wrong side of the line into insulting or whatever it might be. But the belief itself will be protected in whatever forum it's manifested.
Just to build on that, Fergus, because I think that's a really important point about if you're expressing yourself in an intemperate way on behalf of your employer, that is certainly something that's likely to be picked up. But the other aspect is the sum of the substantial reason. So, for example, if the way you conduct yourself on social media demonstrates that there's something about the way that you're conducting yourself that affects the reputation of the employer, that's also something that can be picked up on. So in the case of Page, famously, he was a trust member who had a duty to demonstrate an ability to service the needs of gay mental health service users. Now, for him to also make comments about the fact that it just wasn't normal for two men to be in a relationship together and raise children was something that affected the ability, the reputation of the trust. Even though it may not amount to misconduct, it was still behavior which might have an impact on his ability to do his job. And one of the reasons that the Court of Appeal is so cautious about this is that these issues are very, very nuanced. And it's very important that rather than simply saying, yes, it's a belief, so it's protected, or no, it's offensive, so it's not protected, employers really think quite strategically about what specifically the issue is and what specifically is objectionable about that view, or the manner in which it's being expressed or connected with the activities of the employer. So that's my 2 cents worth in addition to Fergus's take on that particular topic.
Yeah, so the other question we have is, at the moment, is will such a failure be reflected in online harms or employment law, or both? And the question of the online harms bill is one that we don't really know the full ramifications of exactly how that's going to play out yet. But this whole question about online hate speech is one where there's hopefully not going to be all that much room in most cases for a line to be drawn between hate speech that manifests itself in a particular way and the holding of a belief in itself. There is always going to be the Article 17 issue, Article 7 of the Convention on Human Rights to consider, namely whether or not the belief fails the test for protection because it is so, because it excludes the rights of others. So if that applies, then you haven't got a protected belief at all, and that's just a question of employment law. The question of online harms is going to be a rather different one, but the comment that we can make at this stage about that probably is that if workplace speech or speech connected to an employer is going to be something that infringes an act of parliament, then that is going to be a very clear basis for an employer to be able to say, well, you've crossed a conduct line here. We don't even need to decide what we think about it, as long as we're clear that it's prohibited or something that the online platform should have dealt with or has dealt with. That is going to be something that an employer is going to find it extremely easy then to say, oh, well, it clearly falls on the wrong side of the manifestation argument. I think we're anything either of you want to add to any of that discussion?
I mean, I think the only thing, just in terms of, I think just raising the topic of hate speech, what Forstater basically says is that simply having a gender critical opinion in and of itself isn't it. But we can certainly think about twisting the variables about so that it would be something much more controversial and much more inappropriate. So, for example, in Jaguar and Rover, the claimant was regularly referred to by the pronoun it. Now, that's the kind of behaviour that clearly crosses the line. It's designed to express contempt. It's designed to express hostility. Similarly, you can think about expressions which involve the N-word or the F-word. And really, in terms of thinking about where the line is, before we've got any more guidance that comes in the form of further legal authority, really it's a matter of pinning down what are the words used, what are the actions taken, what are the context of this, which would allow me to conclude that this isn't simply somebody expressing a view that I disagree with. This is something which demonstrates a level of hostility or contempt or something else equally unacceptable, which means that something has to be done about this behaviour. So I think that's really what I do want to leave solicitors and audience members with. Just the notion that this is a very delicate and sensitive issue, not least because whilst for some of it, it's a matter of intellectual curiosity, for people who have to regularly experience being subject to very abusive language, it's very easy for them to react still in that position of fear and hostility. And what it is the duty of any responsible employer and any advisor to a responsible employer is, let's just think about where the line is and let's think about what's happening here, rather than on the one hand dismissing concerns as hysteria, or on the other hand pressing aside perfectly legitimate, if slightly objectionable or old-fashioned beliefs. So I think that in summary is my additional thought on the issue. Fergus and Richard, over to you.
I think I'd like to just add on that what I see as an issue for the future, which is this. It's very easy and sometimes justifiable for employers to say the reason we object to what our employee said on social media was it damaged our reputation. But that's not as straightforward an argument as it might seem. What if it's true because the beliefs you're being manifest just simply are very unpopular, however moderately they're expressed? And I don't think that in future damage to the reputation will be accepted as a blanket justification for penalising a manifestation of belief. It's notable, for example, that in Page, the harm on which the employer relied was very carefully and properly expressed, very specific. It wasn't a bland allegation of damage to reputation. It was, we have mental health patients who will be afraid to approach us. Very different.
Good. Well, it's 5 o'clock on my computer, so I think that's drawing us to a close. We try and make sure that we do stick to the time that we said we were going to stick to in these webinars. So thank you very much indeed, everybody, for attending, and we hope to see you next time.